Section 4D, Business Practices. This section covers the North American Securities Administrators Association Statement of Policies on Dishonest or Unethical Business Practices. It applies to broker-dealers, it will apply to agents, it applies to investment advisors, and IARs. These are the things that you do not want to do. So whether or not the IA is federally or state registered, these things apply to everyone. It's a very important section within the law portion of your test. The majority of questions will come from these rules. It's really a list of things that are prohibited. Most of them are common sense. How lovely that some of these will just require your common sense. A few of them are strange, and I'll point those out. Each broker-dealer and agent shall observe high standards of commercial honor and just and equitable principles of trade in the conduct of their business. Acts and practices, including but not limited to the following, are considered contrary to such standards and may constitute grounds for denial, suspension, or revocation of registration. So we start off by talking about broker-dealers. Broker-dealers may not engage in a pattern of unjustifiable delays. So no unreasonable or unjustifiable delays. Securities for customers must be delivered and monies due customers must be dispersed on the settlement date. Broker-dealers may not induce trading in a customer's account, which is excessive in size or frequency. That's called churning. It's done to generate a commission, and it is, of course, prohibited. Broker-dealers may not recommend to a customer the purchase or sale of any security without reasonable grounds to believe that that recommendation is suitable for the customer. The number one suitability determining factor is what is your client's investment objective. You will, of course, also need to understand their financial situation and needs. We have previously discussed that in this course. Broker-dealers may not execute a transaction on behalf of a customer without authorization to do so. Orders can never be taken from anyone other than the customer. So the wife has a trading account and the husband calls up to cancel the trade. Can you listen to him? No, not unless it's a joint account, or if the husband has what is called third-party trading authority. So they're going to make up all these strange stories. Your customer's getting old. His grown son thinks that he doesn't know what he's doing with his securities investments. Can you listen to his son? No, of course not. You can only take orders from your customer. Broker-dealers may not exercise any discretionary power in effecting a transaction for a customer without first obtaining written discretionary authority from the customer, unless the discretionary power relates solely to the timing or price of the security. For example, if your customer calls you up and says they want to buy 100 shares of Ford stock, they told you type and quantity. They automatically give you discretion over timing and price. You do not need it in writing. You're going to do it today at whatever price the market will bear. Of course, you're going to get the best price that you can for your customer. If your customer called you up and said they wanted to buy 100 shares of growth stock, but they didn't say what shares they wanted, you would need written discretionary authority to choose type. So anytime you are choosing for a customer type of security purchased or quantity of a security to be purchased, you need written discretionary authority from the customer. It's a third-party trading authority. Broker-dealers may not execute any transaction in a margin account without securing from the customer a properly executed written margin agreement promptly after the initial transaction in the account. I mentioned this funny rule earlier when we were discussing margin. So the margin rule Now, in reality, broker-dealers are probably going to require that their customers turn in this form beforehand. But the way that the law is written, it says that the customer must sign a margin agreement. It sets forth the equity that's required in the account, how much interest is going to be charged on the loan. It must be signed promptly after the initial transaction in the account. Broker-dealers may not commingle a customer's securities with those owned by the firm. No commingling. So the customer's securities must be kept separate from the securities that are owned by the firm. Broker-dealers may not hypothecate a customer's securities without having a lien thereon unless the firm secures from the customer a properly executed written consent. It's called a hypothecation agreement. When? Promptly after the initial transaction in the account. Hypothecation also occurs in a margin account. So we have these two rules for margin accounts, that the paperwork must be signed after the initial transaction. Broker-dealers may not enter into a transaction with or for a customer at a price not reasonably related to the current market price. And broker-dealers may not receive an unreasonable commission or profit. 20% would be unreasonable. So commissions and profits should be reasonable. They cannot enter into a transaction at a price not reasonably related to the current market price. No excessive commissions or markups. Broker-dealers may not fail to furnish a final prospectus to their customers no later than the due date of confirmation. So whenever you sell a new issue, you must give out a prospectus. The latest that it can be given out is the due date of the confirmation. Confirmation is generally sent the business day after the trade date. Broker-dealers may not charge unreasonable fees for services performed, including the collection of dividends or interest, the transfer of securities, or the safekeeping and custody of customer securities. So they may not charge unreasonable fees. Another way of saying this is that broker-dealers may charge reasonable fees for the collection of dividends and interest, the transfer of securities, and the safekeeping and custody of customers' securities. They may charge fees for those things. Broker-dealers may not offer to buy from or sell to any person any security at a stated price unless the firm is prepared to do so. So if they state a price, a bid and an ask, those are firm for 100 shares for one round lot of stock. Broker-dealers may not represent that a security is being offered to a customer at the market unless the broker-dealer knows that a market for such security exists other than the market made, created, or controlled by such broker-dealer. So if the broker-dealer is the primary shareholder, they cannot represent to their customer that they are offering to sell a security at the market price, because really they control the market because they're the primary shareholder. They would need to disclose that fact to their clients. Broker-dealers may not affect or induce any transaction in any security by any manipulative, deceptive, or fraudulent device. These all sound bad. They're called market manipulation, or sometimes you'll hear the term painting the tape. So do not affect any transaction in a security which involves no change in beneficial ownership. Do not enter orders for the purchase or sale of any security for the purpose of creating a false or misleading appearance of active trading. This happens a lot in penny stocks. Don't do it. Do not affect a series of transactions in any security, raising or depressing the price of such security for the purpose of inducing its purchase or sale by others. Market manipulation is bad. Broker-dealers may not guarantee a customer against a loss. There is no loss guarantee in the stock market. That would be insane. We can wish there was, though. There's no profit guarantee in the stock market either. No loss guarantees and no profit guarantees. Broker-dealers may not use any advertising or sales presentation in such a way as to be deceptive or misleading. Sounds fair. Broker-dealers may not distribute any non-factual data that is designed to supersede or defeat the purpose of any prospectus or disclosure. Broker-dealers may not fail to disclose that the broker-dealer is controlled by, affiliated with, or under common control of the issuer of any security before entering into any contract with a customer for the purchase or sale of such issuer's securities. For example, the broker-dealer that is taking the new issue public. So they're taking a company public, and the CEO of the company that they're taking public is the wife of one of the partners at the broker-dealer. Should you disclose that? Absolutely. So the disclosure, if it's made verbally, must be supplemented in writing. Because the question is, how impartial is the advice to buy these shares, right? So if the disclosure is made verbally, it must be supplemented in writing at or before completion of the transaction. Broker-dealers cannot fail to make a bona fide public offering. I've mentioned that before. An IPO is shares that are sold to the general public. So if you work at a syndicate firm that's taking a company public, as much as you might want to buy those new shares for yourself and tell all of your family to buy them, you can't. You can't buy those shares for yourself. To do so would be to take what we call a free ride and to withhold those shares from the general public. So free riding and withholding are prohibited. Those shares must be sold to the public. Broker-dealers may not fail or refuse to furnish a customer upon reasonable request information to which he or she is entitled. Broker-dealers cannot fail to respond to a written request or complaint. So if somebody requests something in writing, you have to follow through and keep all of those within your books and records. A written complaint, you have to respond, keep those within your books and records. These statements of policy apply to agents as well. Agents may not engage in the practice of lending or borrowing money or securities from a customer. That seems good. Agents, don't borrow money from your customers. Don't lend money to your customers either, however. So they like that on the test. I suppose the only exception here is that if I'm a registered rep, can I borrow money from my mom? Yeah, I don't have to tell my boss. That'd be so embarrassing. Could I lend money to my brother? Sure. So with the exception of immediate family, agents do not want to borrow or lend money or securities to their customers. Agents may not affect securities transactions that are not recorded on the regular books or records of their employing broker-dealer. Unless, for example, let's say I'm a registered rep, my brother wants to take his hip-hop record label public, we'll pretend, so he asks me to help him do a private placement. I can't go on my off hours and engage in this transaction without permission of my employing broker-dealer. So I talk to my principal. They'd have to give me the okay. If they don't give me the okay, it's called selling away, engaging in transactions that are not recorded on the regular books and records of my employing broker-dealer. Selling away is prohibited. If I get permission, they say okay, which they may or may not do. If they said okay, however, I would have to run all of the monies through the books and records of my employing broker-dealer. As an agent, do not establish or maintain an account that contains fictitious information. Seems like a good rule to follow. Agents must be registered in every state in which they transact business with a public customer. We know that. Agents may not share, directly or indirectly, in the profits or losses of a customer's account. Unless, of course there's an unless. If you get permission of your employing broker-dealer, so your principal says that you have the ability to invest with your customer. It's kind of weird. Your customer agrees that it's okay that you invest with them. However much you've invested into the account with your customer is however much that you get to share in the account with your customer. So you get permission of your broker-dealer, permission of your customer. If you put up 60% of the money into the account, how much of the profits or losses do you get? 60%. So if those rules are followed, then it is permissible to share in the profits or losses of a customer's account. As an agent, you may not divide or otherwise split your commission with anybody else unless the person that you're sharing with is an agent registered with your same broker-dealer or with a broker-dealer that's in direct or indirect common control. So if your friend who happens to be an attorney makes referrals to you and you sell securities, can you share your commission with your friend the attorney? No, not unless your attorney wanted to be an agent registered for the same broker-dealer. That would be the only time where it would be okay. Unethical business practices apply to investment advisors and investment advisor representatives as well. So broker-dealers and agents are held to a suitability standard, where IAs and IARs are held to a fiduciary standard. Down the road, in a perfect world, we will see, I do believe, a fiduciary standard for everyone. But until that day comes, IAs are held to a higher standard than broker-dealers are currently. So suitability guidelines for broker-dealers and agents say that you have to make sure that you have reasonable grounds to believe that something is suitable for your customer. IAs and IARs, on the other hand, are held to the fiduciary standard, where everything they do must be in the client's best interest. So it's a slightly higher standard that they're held to. So we have, of course, a list of unethical things that an investment advisor or IAR would not want to do. Some of these are repetitive, but it doesn't hurt us to go over them again. IAs and IARs shall not recommend to a client the purchase or sale of any security without reasonable grounds to believe that the recommendation is suitable for the client, based upon, number one, their investment objective. You have to understand their financial situation and needs and any other information that you can learn about them. Most suitability information is found on a client's new account form. Investment advisors and IARs cannot exercise any discretionary power in placing an order for a client unless they have written discretionary authority, unless the discretion relates solely to timing or price. So this is the same rule as before. If the client tells you type and quantity, you do not need written discretion over timing or price. So you're going to do it today at the best price that you can get in the market. If they don't tell you type or quantity, then you would need written discretionary authority. IAs and IARs should not trade excessively in size or frequency. Once again, that's called churning. IAs and IARs should not place an order to purchase or sell a security for the account of a client without authorization to do so. An advisor can only take orders from their customers. So you recommended that your customer buy company A's stock, and news was released this morning that's causing the stock price of that company to plummet. And you want to sell for your customer. What do you have to do before you can sell that stock? If you don't have written discretionary authority, which you will assume you do not have, you have got to get them on the phone. But you keep calling and they're not answering because they're on vacation and left their cell phone. Good for them. But you can't sell anything for them unless you get their permission. So the test is going to make up all sorts of stories. Do not sell unless you get their verbal permission to do so. Investment advisors and IARs should not place an order to purchase or sell a security for the account of a client upon instructions of a third party without first having obtained a written third-party trading authorization from the client. So it would have been best if that client that wanted to go on a real vacation with no laptop or cell phone had given maybe their lawyer authority, a third-party trading authority that lasted for a period of their vacation or something like that. So a written third-party trading authority lasts until it's revoked or until the client dies. Investment advisors should not borrow money or securities from a client. IARs should not borrow money or securities from a client either, unless, so here's a funny exception to this rule. So IAs may borrow or lend money or securities to a client if the client is one of these three. If the client is a broker-dealer, then it would be allowed. If the client is an affiliate, so a related party, then it would be allowed. If the client is a financial institution, so these are the times in which the IA would be allowed to borrow or lend money or securities to or from a client. So generally speaking, they won't. Agents do not borrow money or lend money or securities to or from a customer, never. Broker-dealers, on the other hand, they're lending money to customers all the time in a margin account. So we don't have these rules for broker-dealers. Investment advisors and IARs should not misrepresent to any client the qualifications of the investment advisor. They should not misrepresent the nature of the advisory services being offered or the fees that will be charged for such services. They shall not omit material facts. Under state law, investment advisors cannot be compensated solely based upon gains. That's called a performance-based fee. So it is not allowed under state law. Most advisory fees are based upon a percentage of assets under management, which is not a performance-based fee. The fee must be for a definite period of time as disclosed in the advisory contract. Investment advisors and IARs shall not provide a report or recommendation to any client that was prepared by someone other than the advisor without disclosing the source. So they may use research of other firms if they disclose the source. IAs and IARs may not charge unreasonable advisory fees. So there is this idea that the fees that are charged at this level must be in line with the fees that are charged by other firms. Investment advisors and IARs shall not fail to disclose to clients in writing, before any advice is given, any material conflict of interest, including but not limited to. So the investment advisory business is rife with conflicts of interest, but they're allowed if they're disclosed to your client in writing before you give the advice. So the fact that you're going to charge an asset-based fee for the advice and a commission on the transactions, that's a conflict of interest. It is allowed if disclosed in writing to your customer before the advice is given. Financial planners are included within the definition of investment advisors. Investment advisors and IARs may not guarantee that a client will make money. They may not guarantee that a client will not lose money. So one of the things that they cannot do, they cannot say, if you have negative performance in your account, I'll waive your fee. That's not allowed. You can't promise that your customer will break even. You can't promise that they'll make 5%. Investment advisors and IARs are not allowed to disclose the identity, affairs, or investments of any client. So maybe you have a professional sports star as one of your clients, and the newspaper calls you up and wants to talk about their holdings. You can't talk to the newspaper, not without permission of your client or as required by law to do so. Your client information must be kept confidential. Investment advisory contracts must be entered into, extended, and renewed in writing. The contract must disclose the services to be provided, the term of the contract, the advisory fee, the formula for computing the fee, the amount of any prepaid fee that would be returned in the event of contract termination for non-performance. Does the contract grant discretionary authority? And the fact that no assignment of the contract can be made. There's what we call a non-assignment clause. So that the IA cannot sell their book of business to another advisor, not without getting first permission of the clients. Investment advisors cannot fail to establish, maintain, and enforce written policies and procedures reasonably designed to prevent the misuse of material, non-public information. So there's this idea of what they call the China wall or the China wall theory. A lot of IAs also have research departments. So your friend works in the research department and just finished writing a research report, which is going to come out next week. Can you trade before the research report is made public? No, there's supposed to be no discussion between the research department and the proprietary trading desk. There's this wall, if you will, in between the two. Just like if your customer was to tell you material non-public information, because, it makes them look good. Tell it to your boss. Let them worry about how to protect it. Do not ever trade upon material non-public information. Investment advisors and IARs cannot ask their client to sign what we call a hedge clause. Although I guess they could ask them to sign a hedge clause. Let's say this. I'm going to go break the law, but sign this thing so that when all is said and done and we're millionaires, you can't sue me for breaking the law later on. If you asked a client to sign it and they signed it, it doesn't hold up in a court of law. It does not absolve you of any liability. So hedge clauses are unenforceable in court. Investment advisors and IARs shall not engage in any act, practice, or course of business that is fraudulent, deceptive, or manipulative, that is contrary to the provisions of the Investment Advisors Act of 1940? Of course not. If the IA has custody of a client's money and or securities, they must notify the administrator that they have custody, because there's other special rules anytime custody is part of the contract. So that's a lot of bad things. Those are mostly common sense, but those rules are not inclusive. There's other bad things that they would not want you to engage in, such as forgery, embezzlement, non-disclosure, incomplete disclosure. Don't misstate a material fact. You never have to state all facts. You always have to state all material facts. Do not engage in manipulative or deceptive practices. If you're found to have done any of these, you could lose your license. It may be denied, suspended, or revoked. You could get fined. You could go to jail. Don't do any of these. You know that broker-dealers, agents, and investment advisors may never make a recommendation to a customer on the basis of material inside information. If you ever learn any of that material inside information, tell it to your principal, tell it to your boss, so that they can keep it safe, so that they can have the wall around it, if you will. That section is one of the most important sections within the law portion of this course. So make sure that you are doing well on the section quiz as it pertains to these rules.